My name is David Harris. I'm at the Charles Hamilton Houston Institute for Race and Justice. I want to welcome you here on behalf of Dean Manning and the law school. Yesterday I gave a lot of thanks and acknowledgments, and I'm not going to repeat all of that, but I did leave one off yesterday, and I want to get it on the record today. And that is for our Office of Communications, which actually came up with this graphic for us. And I happen to really love it, and so I want to give them a shout for having done it. With that, I'm going to turn it over to my colleague to really kind of set the stage for today and welcome you as well. So Phil, if you would take over for us, thanks.
Thank you. Morning, folks. I'm Phil Kassel. I'm the director at Mental Health Legal Advisors Committee. We do legal and policy advocacy throughout the state. We made a decision some years ago to prioritize those issues that affect persons with mental illness or perceived to have mental illness, as well as some other basis for suffering disadvantage. And I think this conference is part of that commitment. We've really enjoyed working with Harvard. They've been great. David's been great, and Kelly in his office. This room is beautiful, and they even got us coffee. So, I mean, we're very, very pleased to have worked with them. Today, we're going to explore how everything we learned yesterday is manifest in maybe the most toxic distillation in the law enforcement and punishment systems. Where the people who suffer or can be characterized as having mental illness as well as persons of color are the ones most disadvantaged, as I think is pretty well understood. The format for today is that we're going to start with the folks I'm about to introduce here to laying out the problem itself, and then we'll talk to three more people who are working on it. It's not a neat division because the people you'll hear laying out the problem are also activists, and the people who are going to be talking about what they're doing have a lot of insight into the problem. So you'll probably hear most, but the concentration will be what is going on, and then after that, what are we doing about it? I want to say that there was one omission from the program. I should mention Megan Mauskoff of our office, who does some really vital work and as our intake director, helped, and she was left off the program, so I want to make sure she gets a little shout. And so let me tell you who's going to be talking. And then David came up with a couple of really, what I understand are really cool videos that we'll see. They're very short. When we go into the second session, after you hear from the folks who are going to tell you about the work that they're doing, we're going to have tables here where we'd all have like individual discussions at tables. I've got some questions for you to answer if you wish, or you can just come up with your own questions, but we want to have people actively kind of using the information and coming up with their own ideas, and then we're going to get together at the end and see what they are. Since we don't have tables, I'll ask you to like do a little kumbaya thing and get together in little circles or something. Move some chairs around so you're comfortable talking to one another, and then we'll hand out these handouts. But now we're going to hear first from Dehlia Umunna. There's more complete bios than I'm going to give you online at the Houston Institute website. But I'll tell you a little something about these folks, who I'm really pleased were able to come here on a Saturday. And then we'll do the videos first. Yes, that is sort of what I had in mind anyway. Okay, let's do the videos, and then I'll tell you who's going to talk to you about them, about the same topic.
That's all right. So one thing for those of you who know, I do have to say that kumbaya is actually, a fairly powerful and aggressive term, which means come by here, and is not to be taken lightly. So we can maybe just adjust that a little bit.
The first microaggression of the day.
See, we're doing work here.
Well, us white people got to own up, right? Isn't that part of this?
No, this is
Good comeback.
So let me see if I can kind of figure out how to get to the desktop. So how do I shrink this?
Be off the stage for the video? Should we be off the stage for the video?
So I'm going to do this. Yep. Okay. All right. Now here I am. All right. So this first one, for those of you, the judges in the room, and anyone who's ever seen my colleague Johanna Wald give a presentation on
the other thing that we need to keep in mind is, as we are all imperfect humans, and as has been laid out in some of the other talks this evening, we all have unconscious thought processes and psychosocial mechanisms that prop up. There are many things in our day-to-day lives that lead us towards developing little pockets of prejudice, that lead us towards acting unkind to others without having any intent to do so. These are things that will just naturally develop in our day-to-day lives. So the problem with that all or nothing binary is it causes us to look at racism and prejudice as if they are akin to having tonsils. You either have tonsils or you don't. And if you've had your prejudice removed, you never need to consider. So if someone says, I think you may have a little unconscious prejudice, you say, well, no, my prejudice was removed in 2005. I went to see that movie Crash. It's all good. But that's not how these things work. When you go through your day-to-day lives, there are all of these mass media and social stimuli, as well as processes that we all have inside our brains that we're not aware of, that cause us to build up little pockets of prejudice every day, just like plaque develops on our teeth. So we need to move away from the tonsils paradigm of race discourse towards the dental hygiene paradigm of race discourse. The other thing that we need to keep in mind is, as we are all imperfect humans, and as has been laid out in some of the other talks this evening.
So again, that issue came up yesterday about kind of how these kind of individual interventions for bias and the need to keep going. And I'm going to play another clip, this very short clip, which exemplifies one of the kind of mechanisms that actually we can think about using to address our bias, which has... Oops, I'm sorry.
I think our race relations are fairly good. If I were black, I wouldn't feel that way.
So that's a great clip from a film that a colleague of ours did, and I do think it gives us an example of this question of kind of putting yourself in another person's steps. And that was a real genuine, that was just a guy on the street in Tulsa. So with that, I think we're ready to get rolling with some serious business. Thank you all.
Turn to our places. Dehlia Umunna is a professor here at Harvard and a lawyer. She's a faculty deputy director of the law school's Criminal Justice Institute. Her teaching interests and research focus on criminal law, criminal defense and theory, mass incarceration, and race issues. Next, we'll hear from Sana Fadel. She's the interim executive director of Citizens for Juvenile Justice. We do a lot of work together at NMHLEC and CFJJ. Which is an independent nonprofit statewide organization working exclusively to improve the juvenile justice system in Massachusetts. Sana is a criminal justice activist. As her career, she serves on the Massachusetts Coalition for Juvenile Justice Reform, which spearheaded efforts to pass a comprehensive criminal justice reform bill very recently. Elizabeth Matos is the executive director of Prisoners Legal Services, a place where I worked for 10 years. Lizz is engaged in litigation, or has been before her ascendancy to the directorship, and probably still to some extent. That's up in the air, I think, a little. The litigation that she's been engaged in, however, involves solitary confinement of persons with mental illness discrimination against deaf and hard of hearing prisoners, draconian classification practices, and she's also worked on a case designed to lower exorbitant and monopolistic prison phone rates. She joined the board at Justice at Work as well in 2017. She practices previously as a legal services lawyer at South Coastal Legal Services, where we work together very happily. She practiced housing, education, disability, and immigration law. So with that, let's start with Dehlia.
Okay. I hope you guys don't mind. I'm going to actually stand. I hate sitting. I really do. All right, so good morning. Good morning. Good morning, everyone.
Good morning.
Just always something to always piss you off, right? If I was black, I wouldn't feel that way. Damn. Okay. I was not expecting to hear that. Now I'm all fired up for no particularly good reason. Okay. So first, actually, I want to thank Phil. I want to thank everybody who helped put this together. It is such a timely conversation to have about these issues as we begin to see a rise of these concerns, quite frankly, in the criminal justice system. I want to thank Robert Hernandez and Dave Harris, and it's always a pleasure to see the Honorable Judge Blitzman back there. So I want to actually start off with a quote that I think is really important. And this was a quote by somebody whom I miss so dearly and wish so much that he could come back. And it says, "Our criminal justice system isn't as smart as it should be. It's not keeping us as safe as it should be. It's not as fair as it should be. And mass incarceration makes our country worse off, and we need to do something about it." And that was President Barack Obama in 2015. And so that sort of highlights where we are in terms of our criminal justice system and what's happening. And I thought I would start off by giving you two anecdotes, really, of cases that I've been involved in that sort of highlight what's really happening with race, racism, and mental health. So the first one is of a young man who's 13 years old, and I will, for this purposes, call him Timmy. He was charged with assault with a dangerous weapon, and as it turns out, he was really functioning at the level of a 7-year-old. This case actually ended up in Lowell District Court, Juvenile Court. And I received a call from a colleague of mine at 11:30 a.m. saying, "Dehlia, you know, the police want to talk to this young man," and his mom called me. "What do you think we ought to do?" And I'm like, under no circumstances would a 13-year-old talk to a police officer, right? So the next day I went and I spoke with Timmy, and it was very clear to me, just in speaking with him, that he was functioning at a level of a first grader. He had been undiagnosed, had several issues that were very important in terms of how his behavior manifested and leading to his arrest. Luckily for us, and luckily for him and his family, he had us representing him. We filed a motion to dismiss in the interest of justice, which was heard before Judge Blitzman, and Judge Blitzman did the right thing, recognizing that the mental health issue was important, was an indicator in this particular case with regards to where this young man was functioning. I also, while I'm up here, wanted to acknowledge Ms. Freitas, who was amazing in helping me navigate Lowell Court. It's amazing what happens when you step out of Cambridge. Okay, there are good people everywhere, is basically what I'm trying to say. And so we were able to provide Timmy with not only the fact that his case was now being dismissed, but also the help and treatment that he needed, right? He was referred to the education clinic here at Harvard, realizing that he had suffered so much trauma, and then providing him, suing, you know, the Boston School Department, the Lowell School Department, and now he has the help that he needs, right? But he's very lucky, right? He had Harvard step in. He had top-notch lawyers who stepped in to intervene in his case. The second case I want to talk to you about is one that happened in April. And so at 2:30 a.m., I'm not sure why I keep getting all those late night calls, but I do. And I also don't understand why I pick up my phone at 2:30 in the morning, but I do. 2:30 in the morning, April 16th, one of my colleagues called me frantically and said, Dehlia, we have an incident right here at Harvard on Mass Ave. And I said, what happened? And he said, well, one of college student was walking around unclothed, and he was grabbed by the police responded, and what ensued was a very violent, ferocious beating of this 21-year-old black man. It was captured, as some of you may know, on video, led to his arrest for several allegations. I can't speak much more to that because there's an ongoing investigation. However, it was clear to anybody who was paying any sort of attention that this young man was having a mental health breakdown, right? And the response shouldn't have been to beat the crap out of him, right, and punch him. The response should have been to recognize that there was a mental health issue that required intervention, that required treatment, but that did not require the sort of beating that he suffered that night. He's doing well. I think he's doing well, but that's the sort of experience that you don't ever forget. So these individuals, in my opinion, have been very lucky, right? The gentleman that I just described was lucky that that incident was captured on video. He was lucky that he had, again, top-notch lawyers intervene. He was lucky that he had the media scrutiny that ensued. He was lucky that he had people who were willing to fight for his rights and for the charges against him to get dismissed. But that's not the case, quite frankly, for a lot of our clients, right? They don't have the media scrutiny. They don't have the attention that these the individual I just described had in this particular case. And what we do know is that, for example, I do know in the past 20 years of representing people, most of them, whether it's juveniles or adults, most of them have been people of color. And I also do know that mental health, a sizable percentage of that population has had mental health issues. And I have to be honest with you, when I first started practicing, I was clueless to this idea that individuals suffered from mental health issues, right? With the idea of the gentleman that I just described to you, it was easy for his mental health to be treated or defined as defiance to police officers. And because they defined it as defiance, right, it was easier for them to get into a posture where they were beating the crap out of him. And so we do know that from mild depression, there's a range there, from mild depression to bipolar disorder diagnosis. Our clients actually mirror the general population. And when it comes to dealing with mental health issues, the main difference is that when you're black and poor, right, and undiagnosed or sometimes misdiagnosed, and then not treated, and then you layer that with a co-occurring substance abuse issue, you are going to be targeted, particularly if you get caught up in the criminal justice system. And for a lot of our clients, your life gets down a trajectory that can be very traumatic and can have results including death. I have a few numbers for you that I found to be quite startling. 862. Can anybody hazard a guess as to what that number is? And don't tell me it's the three numbers you have to play for the lottery. So 862 is the number of folks who, as of today, have been shot and killed by the police this year. This year. 21% of that number have been Black African Americans. 159 of that number have been individuals who were identified with some mental health diagnosis. In 2017, 987 people were killed by the police in these United States. Of that number, 237 were diagnosed with mental health issues. In 2016, 963 individuals were killed in these United States by the police. Again, of that number, 242 were individuals diagnosed with mental health issues. In 2015, 995 people were killed by the police. And of that number, 257 were individuals identified with mental health issues. So if you tally the numbers going back to 2015, we have at least almost 1,000 individuals of the almost 4,000 people killed who were diagnosed with mental health issues. That is a problem. That is a problem. Now, we do know that every year over 12 million people move through America's local jails, mainly on low-level nonviolent misdemeanors, costing local governments over $22 billion. What we also find out, the data shows that 64% of those people suffer from mental health illnesses. Imagine that. If you were involved in anything and they said 64% of such has X, it will be a crisis. And it seems like here in the United States, we rarely care about that. And I attribute that to three main things. Racism, it's just what it is. I mean, we just saw example number one. If I were black, I wouldn't feel that way. Well, I wake up every morning and I look and I'm like, still black, right? And got to deal with it that way. And the second thing is stigmatization. The way we view mental health, particularly with people who are involved in the criminal justice system, has to change. In other countries, I was born in England, and in other countries, we are beginning to at least see a change in how we describe mental health and in how we treat mental health so that we can destigmatize it and provide the help that individuals do need. And then the third, in my opinion, big bucket is this idea of the failure to diagnose. For a lot of our clients, I believe that if we had cut the disease or cut and made diagnosis when they were much younger, we could have started treatment that will prevent them actually from getting involved in the criminal justice system. And so I see that my time is almost up, and I will do my very best to be obedient and stick to the time. But I did want to say that it's going to be critically important for us to join forces, particularly when it comes to police officers and first responders and practitioners. I don't think that you should be an attorney handling a case without having had mental health training, period. You shouldn't. It should be a malpractice for us to do so. It should be. You shouldn't be a first responder or police officer who has not had training on how to identify mental health issues, particularly in black and brown people. You shouldn't have a badge, and you sure as hell shouldn't have a gun. There are some states, about 27 states, and the District of Columbia, for example, who have laws on the books requiring officers to be trained to respond to mental health and substance abuse, behavioral disorder issues. And laws specify which officers are to be trained, which entity is responsible for conducting the training, and they provide funding for this to happen. Data has also shown that when first responders and police officers are trained to identify mental health issues, the incidence of police shooting and police violence towards individuals drops dramatically. So it is my hope that we will be able to rally around this issue, not only as it affects black and brown people, but as it affects all people, quite frankly, particularly poor people. I will sit because I know that I can talk for longer than the time allotted. And then after my esteemed colleagues are up here, I will take whatever questions that you may have. Thank you.
Can you guys hear me if I sit here? So thank you all. Thank you for MHLAC and Charles Houston Institute for inviting us to be part of this panel. This is exciting. And thank you for all of you for being here. My name is Sana. I'm the Interim Executive Director at Citizens for Juvenile Justice. We're a statewide advocacy organization working on improving the juvenile justice system in Massachusetts. So before I start, I just want to see how many of you actually work directly with children? Can I just see a sense of how many? Awesome. Because what we talk about, we're going to be talking about young people. I talk exclusively about young people. I know Liz is going to talk about the adult system. So if I talk about the criminal justice law or any of these things, I'm really talking about young people in Massachusetts. And we focus exclusively on Massachusetts. So the juvenile justice system is its own distinct system than the adult criminal system for a very specific purpose. The intent was that children, if they violate the law, they shall not be treated as criminals, but they should be treated as delinquents, and that the state should treat them as close as possible to a parent. That comes from our statute and also reinforced by SJC case law. So a lot of the intent of the juvenile justice system is all focused on how can we improve the experiences of young people so that they can develop into positive adulthood. So there's a clear distinction between the two justice systems and the missions of the two systems, which drives a lot of our work. That kids are different, they should be treated differently than adults, and if we treat them looking at them from a developmental lens, like how can you help them develop into adulthood, rather than a punitive way, you will have better outcomes. So that's sort of our mission. And our job as advocates is to say, well, this is where we should be, and this is where we are. Sometimes we're far, and sometimes we're close, and sometimes we're just there. And that's where our job is as advocates. We do this through 4 roles. One is research, education, coalition building, and advocacy. And all of those are tools we use. We are not direct service providers. We don't directly represent kids, but that's why we work in coalition. Like Phil mentioned, we have a statewide coalition of organizations and individuals who help us build up what it is we're working on. So going back to who are these kids we are advocating on behalf of? So typically we're looking at, so our population is children and young people in Massachusetts. The formal jurisdiction of the juvenile court is starting July, as age of 12 up until 17, up until your 18th birthday. That is the jurisdiction of the juvenile justice system. But when you look at who is at risk, we're talking about from birth, actually, and who is the one who are funneled into the juvenile justice system. So what we know is from looking at the profile of kids in the juvenile justice system, and when I talk about that, I'm not talking about lockup and DOIS. I'm talking as, the first step of entry in the juvenile justice system is a child behaves in a certain way, and someone has to identify that. Is that one, criminal behavior that requires the full force of the state, or this is childish behavior that they'll just grow out of, or option 3 is this is behavior that signifies a need of a child that is not these other two. Like you have to do something, but it's not a crime. So that's where we try to, but someone has to make that decision. And disproportionately, who gets that first response? We know young people who live in predominantly low-income communities, young people who are Black and Latino, young people who have special behavioral health needs, special ed needs, and mental health needs, kids who have child welfare histories. And then, so the child welfare piece I'm going to bring up again because that comes up a lot. But if you look at but these are the folks that they get overrepresented at every single stage of the juvenile justice system. Who gets identified? Who gets arrested? Who has a court case? As you go deeper and deeper in the system, the number of kids decreases because at each point, someone is making a decision, nah, they don't belong in the juvenile justice system. No, I'm gonna find another intervention. No, someone called for a police, but we're gonna divert. We're not gonna prosecute. We're not gonna, at all of these, there is a decision, keep going further or keep going. So it's like a game of snake and ladders. Is that, it's like keep going or exit. So those kids who are predominantly enter deeper and deeper are those are the populations. They are not any different than any other child, and have to talk about that, because there's a lot of things we hear like, well, they're different. And if anybody tells you they are different, that is code. They are not different. Looking at public health data, self-reporting data, all these surveys we have of young people, they all behave the same way. Underage drinking, underage sex, fights, they are consistently, there is no disproportionality at the point of the behavior of the child. It's what we as adults and our formal systems do that drive these disparities. We also look at, so even though we look at the juvenile justice system, we're also looking at young adults. So and this is where we sometimes go into the adult realm. For those who are, once you reach your 18th birthday, you're in the criminal justice system, you are considered an adult. Many other systems, you're not. You're kind of transition age youth, and in the human services world, in the public health world, and in healthcare. No, you're still considered in the child serving agency. Criminal justice, 18th birthday, you're an adult, and you have that whole different system that Lizz is going to talk about. So what we also talk about is this population. That same overrepresentation happens there as well. And our specific focus are young people under their mid-20s, because for them, they are still in this developmental stage, and we want to be able to address their needs. So how do we do it? So when we look at the work, when we started 20 years ago, we were all looking at the juvenile justice system, like reforming the juvenile justice system and the deep end, how to make sure it's developmentally appropriate, what about, reducing incarceration, all sorts of things like that. In recent years, we've been saying, well, when we're going here, the harm has happened already for kids. So just to give you why we're looking early. So research shows that there's this one massive research of all sorts of kids, and there was a large enough cohort to be able to try to put them into different categories, that there are enough people in the same background. So same socioeconomic, same educational attainment, same behavior, same everything, like this cohort, this cohort, this cohort. And what they said is, if you have everything is equal, education status, what their family is like, what their income is like, what their race is like, if you have two kids who have the same exact behavior, again, that's not different, but one child is arrested and the other one is not, that doubles their risk of dropping out of high school. If that arrest leads to court processing, you go to court, your risk of dropping out of high school increases 5 to 8 times. And for young kids, educational outcomes is the #1 driver of what happens to them as adults. So that's why we're like, we need to go about the very beginning, when someone decides this is criminal behavior that needs to be addressed. So there's 2 major drivers we saw. One is schools, and the other one is the child welfare system. These are agencies that work exclusively with young people. They focus on young people, and then that's when trouble happens. And that's where, two kids do the same exact thing. Oh, but you're a violent kid. Oh no, you're just acting your age. That's the decision that happens. So based on and then the child welfare system, that actually has even more repercussions, because children in the child welfare system have had their own experiences of trauma. So whether it's, coming into what happened to them to get them into the attention of the child welfare system, but also if they are removed from their families, that itself is a significant trauma. And what we also found when we did our research, so removal from the home is a risk factor of entering the juvenile justice system. Again, I'm not talking about what the child does. I just want to make sure you see that. Removal increases the likelihood of juvenile justice involvement. If you get placed in foster care and you bounce from place to place, that exacerbates the risk of entering the juvenile justice system. And that has a clinical component to it. But when there was a research that came out of a national trauma center that looked at the experiences of kids and measured what harms kids the most. And they looked at kids with significant abuse, physical abuse, neglect, sexual abuse. And what they found is this experience causes trauma, but placement instability, when they bounce from place to place, causes more harm to these kids than the original abuse, including if it was sexual abuse. That's how bad it is. And that's where I was like, we have to address this. When every move a child has, it harms their development, and they will eventually lead to 2 types of behavior, because it's either internalized, something's wrong with me, and they deal with self-harming behavior. They end up in the psych units. Or they externalize. I'm angry at every single human in my life. Every adult has promised everything will be good, and you all lied to me, and I don't trust you. I have no attachment to anybody. I'm angry. They'll be coming to the juvenile justice system. So that's where the harm is. So that is the behavior, but we have to look at what caused that behavior. Because once at that point, we're like, well, you have to be responsible. We have to fix what you're doing, all these things. Nobody ever looks at, well, this is what we as a system have done to these kids. I want to tell you what we did this past spring. Part of our coalition, there was advocates for kids, advocates for adults. It was a statewide effort, grassroots, professionals, individuals with experience, everybody. It was a big coalition of folks who worked on criminal justice reform. We just had one piece of it, and our focus has been on the kids. So I'm going to only talk about what passed recently on behalf of kids. So one thing, remember I told you, as of July, the youngest was 12. Before that, it was as young as 7. We were able to raise that to age 12. The other thing is parent-child privilege. So you talked about, don't have a police officer not talk to a child without a parent. Before the law passed, there was no parent-child privilege. So many of your attorneys, you understand, your kid, the person you're representing will talk to you about anything because you won't use that information against them. There was not that same protection if the child was the one who was the defendant, that if they talk to the parents, there was no protection that information the parent has can be used against them. Now it's the law. We also, I know MHLAC was huge in this, and many of the other coalition in the group that you guys convened, decriminalizing misbehavior for kids in schools. If a kid bangs lockers, or disrespectful, or rude, or obnoxious, or just disruptive of class, it is now the realm of school. It's a school discipline issue, the school administration. It is not a police matter or a court matter. We're also able to, around diversion, judicial diversion. So you talked about this case, and Judge Placement in this case was able to dismiss a case. That kid has a record, right? Even though everybody says, it's fine, you didn't need this was not the right record. You have a record.
So.
Oh, prior to
yes.
Okay,
yes,
excellent. So that is new.
Yes.
That is new because of the law. Prior to having judges be able to say, like, this is a stupid case, I'm going to dismiss it or send it to diversion, prior to arraignment, that is new. But we're not done yet. There's a few things that we haven't been able to accomplish, and this is why I invite all of you, if this is things you care about, join our work. We are all about advocates bringing people together and knocking on doors and making calls and sharing stories. We're not done. So we talked about some of the things that we haven't been able to accomplish that are going to be things we want to work on. One is this issues of records and expungement. The law now creates an expungement statute, but it's extremely limited. So if you have, I'm going to give you an example of a child. In one of our studies, a 14-year-old kid with autism, he was arrested in school because of his autism. The police officer grabbed him. He was flailing. So the kid was arrested for disturbing a school assembly, resisting arrest, and assault and battery on a police officer. 3 charges, that kid is not eligible for expungement. That's the exact reaction I wanted. So we're like, that's not enough. And they excluded a lot of charge offenses. Like, no, you can't do that, you can't do that, you can't do that. So if a lot of kids in the juvenile justice system come in because they fight with their stepbrother or their parent, interfamily fights. Those are considered domestic violence. You can never expunge those. You can't even divert those in the courts. So there's things like that we want to address. The foster care issue, we really have to tackle the placement instability piece. That is something that people's like, yeah, it's a bad thing, but we have to keep kids safe. And I'm like, you are not keeping kids safe if you're not talking about stability from day one. And then the other pieces for the young adults we talked about, we want to have a 2-track process. One is in 2013, before 2013, 17-year-olds were considered adult in the criminal justice system. We raised that so that they're considered in the juvenile justice system. We are, as advocates, trying to keep kids out. We see this as a harm reduction model. There is a role for the justice system. We think it's too big. We want to reduce it, but for some people, the juvenile justice system, it's way better than the adult system. And our argument is what worked for 17-year-olds, 18, 19, and 20-year-olds. So I mentioned other agencies and other systems that see these are transition age youth. They belong in the juvenile justice system. It's focused on rehabilitation, family engagement, education, confidentiality. All of these things are all in the juvenile justice system, and light years ahead of the adult system, they will do better in the juvenile justice system. That's our argument. And then for those in their mid-20s, we want to be pushing for a more humane and developmental approach for these young adults in the adult systems. And then one of the other things we're thinking about is around competency. You talked about the 13-year-old. I'm going to grab this, you don't yank it from me. Last sentence. So the issues of competency. For those of you who are lawyers who work on competency comes up around mental illness as well. It comes up a lot. However, there is no separate standard for competency for kids. Like if I'm a 12-year-old, very different in court than I'm if a 30-year-old, but there is no separate standard for kids. And this is not even about mental health, it's just about their development. And so that's another thing that might be talked about. So if you're interested in any of these things, talk to me. Thank you.
I'm going to stand.
Lizz has a PowerPoint. So
somewhere. Here, I can help you if you want to start. That's you right here. Thank you. Yeah, I think so. Yeah. Awesome. Yeah, okay. Good morning, everyone. How's everyone doing? Good. So I know we're talking at you a lot, but there's been a lot of great information already this morning. I've learned a bunch, and I've worked with Sana, and I'm always impressed with everything I hear. Depressed, but also impressed. So thank you, Sana. I wasn't here yesterday, but I know much of what was discussed focused on the impact of discrimination on people of color, both psychologically and physiologically. And I also know that there's a discussion that I'm not going to get into, but I want you to keep with you as you hear my comments and see these slides. But there's also obviously the disproportionate contact of people with color, black and brown people, with the criminal justice system, starting from very young ages, as you've already heard, and then up through their entire lives with policing practices, in addition to school practices and school arrests, but policing practices, sentencing, and all of that. And so now we're taking that, and we get these folks when they're in prisons and jails in our state. And just prison in and of itself is already a traumatizing environment. So we're adding that to the mix. I just want to give you a little bit of context in terms of who we are. My name is Elizabeth Matos. I'm the Director of Prisoners Legal Services. I've been there for about 8 years, but just as director since July of this year. So I was litigating cases in this context, and finally offloaded those cases and mostly functioning as director. But many of you may not know what we do, so I just want to tell you a little bit about that. Very quickly, so we provide civil legal assistance to prisoners in Massachusetts in about 30 facilities across the state. And we focus on some individual advocacy in these general areas, but we also do litigation, but our litigation is impact focused. We're a relatively small office, and there are roughly 19,000 prisoners in the state of Massachusetts. So we have an attorney-client ratio of about 2,300 to 1. So we do as much impact work as we can. So healthcare and mental health care are our top issue that we hear about in the office. If you don't know this already, you should know that healthcare and mental health care in the correctional system is abominable. It's pretty bad, and that's across the board, across the country. but it is substandard, to say the least. So we hear lots of complaints, things as basic as getting dentures to be able to eat, getting chemotherapy for someone who has cancer. And so that's just on the basic physical level. And then mental health is a whole other area that's grossly inadequate as well. We also handle a number of assault cases, so staff assault on prisoners. Extreme conditions of confinement, that's kind of a broad category, but anywhere from overcrowding to litigating these exorbitant prison phone rates that are taxed on the families of folks who find themselves incarcerated. And then segregation, which is also known as solitary confinement, but now under passage of the Criminal Justice Reform Act is restrictive housing. So that's just a glimpse at what we do. And these are the state facilities in the state that we cover. Corrections is divided into state facilities and county facilities in Massachusetts. The state facilities are under the Department of Correction. Those are folks doing sentences above 2.5 years. And then the county facilities are individually run by sheriffs and superintendents. And these are the county facilities in our state that we cover. So the only facility we don't cover is the federal facility in Devens. So we don't do the Bureau of Prisons, the Federal Bureau of Prisons. But we do take cases from ICE detainees who are locked up in units that where ICE contracts with some of these county facilities, particularly Bristol, Suffolk, Plymouth, and Franklin has a small population. So now I want to give you just some basic stats so you understand the population that we're talking about. This is just Department of Correction data, and you can get this on their website. So we have roughly, actually the numbers are a little bit higher than this as of January, so it's close to 9,000 males who are incarcerated in Department of Correction facilities. Average age is 42 years old. 95% serving sentences of more than 3 years. 70% violent governing offenses. And then as you get a little further down, there's some other interesting statistics. 42% entered the DOC with less than a 9th grade reading level, and 44% entered with less than a 6th grade math level. And then 31% were open mental health cases. So that's not open mental health cases when they came in, open mental health cases in January of 2018. 7% were considered to have what's a legal fiction known as serious mental illness. And at the time of this reporting, that's a very narrow definition. And I would say in our office, we feel pretty confident that Department of Correction misdiagnoses and underdiagnoses folks who have serious mental illness because it carries obligations that they don't want to comply with. And then 22% were on psychotropic medication. And then I've broken this out for women as well because I think it's really important to see some of the differences. It's very much a smaller population. Less women are incarcerated than men. You have 537. Some of the numbers are relatively similar, but when you get down to the last bullet point, 79% are open mental health cases. 12% had serious mental illness. That's an accepted diagnosis of serious mental illness. And 55% were on psychotropic medications. Those are really high numbers. But I will say that this is not uncharacteristic of the statistics for women across the country. So it's not unique to Massachusetts. They're probably a little bit higher than they are in a lot of jurisdictions, but those are fairly high numbers. There may be some, we don't really know why this is. There are some theories. One may be that women report mental health diagnoses more and get diagnosed more than men, particularly women of color and versus men of color. But it might also have something to do with women's separation from their children who are incarcerated. There are maybe a number of factors, but suffice to say that that's a at those numbers, you can imagine that the mental health services being provided are extremely inadequate and not addressing this problem, especially because the numbers have stayed this high for many years. Those are DOC, only DOC numbers, yep. Unfortunately, we don't have the data for the counties. So this is just to give you an idea of the racial breakdown, and as you can see, non-white folks comprise well over 50% of the incarcerated population in the Department of Correction. And this is just to give you, again, the gender breakdown. And this graph is giving you like kind of newly committed people. So the other numbers were kind of who is in the Department of Correction as of January 2018, but these numbers are people who have recently entered the system as sentenced. And still, you can see that 50%, over 50% are non-white. And I think everyone here knows that the population in Massachusetts of folks of color is in around the 20% range. So, and this is just an age breakdown. So the majority of folks coming in are between the ages of 20 and 40. But I have some interesting statistics about what happens for younger populations too that I want to mention, since Sana just gave us that helpful information about youth. So we know that folks enter the system with all of these issues. And we know that prisons are not doing a good job at dealing with folks' mental health issues and a number of other issues. But we also know, although we don't have data for this, we know anecdotally at least that Black and brown folks in prison are disproportionately impacted by discipline practices. So they're disciplined more than white people in prison. But also the stats that we do have show that folks in the Department Disciplinary Unit, which is the most restrictive solitary confinement unit in the state, and actually one of the most restrictive in the entire country, we're one of 3 states that still sentences people to up to 10 years in solitary confinement for a disciplinary infraction. In that unit, it's over 70% Black and brown people. So we know that is happening, and we know that young adults between the ages of 18 to 25 comprise most of the disciplinary tickets. There are lots of places where folks of color have mental health issues are disadvantaged in the prison system. There's a classification system which determines where you get placed in the Department of Correction, and that determines what access to programming and education you have, and also what access to services that will help you get paroled and get released from prison. So the maximum security facility in Massachusetts is called the Susan Baranowski Correctional Center. There's a dearth of programming there. There's 0 substance use programming. And there's a much higher percentage of folks of color in that facility because they take a lot of people who are gang involved. So that is already disproportionately impacting that population. Also, a few other statistics worth mentioning. The suicide rate is higher in prisons than it is in many places, but higher in solitary confinement than in any other environment inside or outside of prison. And I've already told you that folks of color are disproportionately placed in solitary confinement due to discipline. And I haven't mentioned yet, so if you don't know the statistics, I'll tell you that over 80% of folks in prison are diagnosed with mental health diagnosis or substance use disorder. That is a very high number. And there is very little drug treatment, the treatment period, but drug treatment in particular happening in our prisons and jails. That's about to change somewhat due to the passage of the Criminal Justice Reform Act, but not too much. So I'm just going to go quickly through the next few slides. The Criminal Justice Reform Act that Sana alluded to passed in April of 2018. And I'm just going to focus on the solitary provisions of that because of the mental health impact or consequences, and also the impact on people of color. There were other things that that bill dealt with related to prisoners, medical parole, LGBTQI prisoners, visitation and phone rates. But the new standard, which should prevent people from lingering in solitary confinement as much as they do, they shouldn't be there unless there's an unacceptable risk of harm that's being presented. Also, the definition of serious mental illness was greatly expanded under the new law, and to include things like anxiety disorders, bipolar disorder, other trauma and stressor related disorders that were not previously included. And there'll be much more access to mental health services in those units, but not necessarily an infusion of more mental health services overall in the system. So it remains to be seen how that will actually play out. But also there'll be some improvements in conditions, more out of cell time, and more access to reentry services. There are lots of people that are released directly from spending long periods of time in solitary confinement to the community. And that has been a public safety disaster, if not just completely irresponsible. And so we tried to address that problem with this legislation. But we've gotten data. Basically, 2 years ago, we were able to get some budget language that required the DOC to report some data on solitary confinement. They've never been required to do that before. And it's estimated about 21% of the criminal male population in custody experience solitary confinement. The most recent figures show that over 3,000 people experienced solitary confinement between the months of January and June of 2018. So these are just some figures on that. That was last year and this year. So over 3,070 male prisoners were placed in what they now call restrictive housing in a 6-month period. I'll briefly mention some recommendations. These are really just conversation starters, somewhat simplistic, but aside from reforming a lot of the practices we need to reform, one thing we haven't really talked about is trauma-sensitive learning and trauma-informed methods of dealing with, listening to, and interacting with children. And it really does start there. I firmly believe that. But we can't forget about people once they get into the prison system. The Department of Corrections spends just a little over 2% of its entire budget on programming and education. And if their main function is to rehabilitate people, then that clearly is not being shown in the resources they're allocating to this work. So we need to keep people out of the system, but we can't forget about them once they're in there. Thank you for your time.
Thanks, everyone. We're running late, but I don't want to put these great people before you without giving you a chance to ask them the questions you might have. So if people want to start lining up, that would be in front of the microphones to ask questions. Why don't we take about 10 minutes to do that before we move on to the next panel. So we'll be an even 15 minutes behind. In the meantime, okay, well, never mind what I might ask to get us rolling, because it seems like we're ready to roll. Why don't we start here?
Hi, good morning. Thank you so much for speaking today. The question that I have revolves around the new criminal justice reform legislation, and one part of that to try to deal with the school to prison pipeline that we have in Massachusetts was the implementation.
Do me a favor, could you speak into the mic?
Was the implementation of more robust MOUs and SOPs. The on-the-ground experience that we're having with that is that there are certain school districts that are following the model attorney general's MOUs and SOPs than other school districts. And so particularly in the school district that I work with, where we have a very diverse population, we are seeing the DA school teams implementing a less robust MOU that does not follow the same provisions that the AG model MOU has. And so what do we do about that? What's our next step in trying to get them to follow the model?
Can I ask?
Interpret that a little. Okay. Somebody interpret that a little for those of us who might not remember what it is.
So part of the law that says around the school to prison pipeline issue, one was decriminalizing offenses so that if you're a public order offenses, you can't arrest these kids in school. But the other thing was, the whole intent was not to get police involved in routine discipline. So what they created was the law says if a school employs a school resource officer, the school district and the police department, the municipal police department, have to enter into a memorandum of understanding that will delineate a few things. Something that the intent is that the role of police is for public safety. Everything else belongs to schools, and had certain requirements. Some of them around training, some of them around confidentiality, some of them were around data. There's a few things you're supposed to do. The law said that there should be model language so that you don't have 450 MOUs, because every school district, charter, vocational, all of these are on their own school districts. So rather than having like 450 random ones, the state will come up with a model language that makes it easy for folks to be consistent with it. The model language this is model language, but it had, if you looked at the AG's language itself, there were some things that were in bold. Those were the things that are required by law. Everything else, this is good practice and this is how to apply it. For example, some of the language around the state law doesn't require it, but federal law has protections for kids with special needs. So it included that there. One of the things I know we're actually talking about, like what are next steps? You want to be able, so first thing, who knows about it? Who doesn't like it? Are there folks in the school committee? Is there like the CPAC in your school? Because kids with special needs are the ones more likely to be arrested. Would the CPAC be the one interested? So one of the things the first step is compare do you have a copy of the MOU?
Yes. Okay, so you compare the MOU to what the model language says. Being able to signal what are the things that stick out, and then figure out, who would be the right advocates with the school district. Like, is it the school committee? Is it a parent, the school, the CPAC, or what? Is it a group of? Does your school have a group of students who are activists? I don't know, Phil, if you had any additional thoughts.
Yeah, as Sana mentioned earlier, MHLEC has been very active on this issue, and what we recognize that this, all the work that went into putting the provisions that Sana just mentioned into place is not going to really bear much fruit unless we work really hard at trying to enforce it. And so really what we recognize is that folks in localities on the ground need to be aware of the extent to which this is, there is compliance or non-compliance, and getting together on the local ground to put in localities to put pressure on schools and police to do what they're supposed to do under this bill. Matt Kreger, who's right here, is going to lead our portion of those efforts, and we are actively getting MOUs from districts and then analyzing them as you have done. And we're trying to, we're there to help you with this. So please, before you leave today, let's connect. And June, did you have something pertinent you want to say to her?
I just wanted to say that Massachusetts Criminal Justice Diversion Project would like to be helpful as well. We're in 100+ police departments around the state working on death response to people with mental illness and substance use disorders. And we do a lot of community building between the schools and the police. So I would love to work together with you, and I'll take my part.
Okay, thanks. Let's go here so we get some more questions.
Thank you. Are you familiar with reactive attachment disorder? That's a disability that is state created by DCF when they pull young children out of the homes because of the drug addictions and the other issues that are going in the homes, and these kids are placed in one house and then another house and another house. And these kids have severe mental breakdown that is state created, not internally. Yet when they break they have issues, they end up getting criminalized because of the state-created disability. And what can we do to fix that?
Thank you.
So right now there's two things we're working on in our advocacy. One is trying to work with the Department of Children and Families and trying to get them looking at their practices and how do you make those decisions, because right now it's the social workers use I think the formal term is a gut assessment tool. Basically trying to figure out like how can you have what there are tools out there to help them make better decisions, whether to remove, whether to move. That's one. The second piece is around being able, if they have to be removed, the most stable placement is with family, friends. It's called kinship placement. Because of the over-criminalization of Black and Latino communities in Massachusetts, there are families who would be resources for these kids if they're Black and Latino. They're more likely to have records. So DCF has a very strict background check that eliminates a significant portion of young people being able to be placed with kin. So we want to tackle that. And then the third thing is, I mentioned like very few people talk about the placement stability. We want to be able to have DCF publicly report on the who gets what's the placement numbers, what's going on, so that we can use that as an advocacy tool.
Yes, but DCF is creating that disability. And under state law, we can only sue the state from essentially within 3 years of a disability or an incident happening. So these kids essentially are left without the ability to go after the DCF for the creation of this very, very serious disability, except possibly once they turn 18 on a federal level. So how do we get DCF to stop creating reactive detachment disorder?
Those are the tools we have. We don't do impact litigation, so we can't talk about that.
No, I would say that, you know, this theme is something we could have a whole conference on, and how the state, rather than remediating, you know, worsens in the school context. Kids are traumatized. Kids go to school and are re-traumatized, and then trauma is exacerbated, or the impact of it is exacerbated. And Liz mentioned the extent to which people are placed in solitary confinement. I mean, there's, you know, any expert in that area will tell you that, or any expert isn't employed by the state, will tell you that the impact of that can be devastating and long-term and even irreparable. Let's take one more question over here, and I'm afraid we're going to have to move on. But those of you who have things you want to say, you're going to get a chance to talk in a relatively short time between each other. One more question.
All right, I'll try to make this brief. First of all, thank you for your sharing information. And so my question replies to a comment Santa made during the presentation. So you said that once the youth get involved in the system, there's this whole process that decides what's a crime, what's not a crime. And so the comment, I was thinking like some of these decisions are irrational. And I can only think about the youth that have been killed by the police in the past. Trayvon Martin, the youth in the park playing with a toy gun or whatever, but it's these projected labels that get put on kids that place them into the criminal justice system. And so I guess my question is, to what extent does adults' preconceived biases play into children being charged as adults once they get into the system?
Where does bias play in? At every single stage? I mean, that's the thing, like with us, as advocacy, our tools are advocacy. We don't do like individual training with folks to identify implicit bias, for example. Like each one of us has a role to play, and knowing what tools you have. So that's why for us, like changing laws are tools. Well, we know there's going to be bias. So how can we change the laws to restrict the range? But we're not really addressing implicit bias through these tools.
Do you want? I already cut it off because people said that. All right. Yeah, I mean, one of the problems here is you could change standards, but how do you change hearts and minds? But we will be talking in the next panel about that issue, and we have people who are actually trying to do just that. So why don't we move on to the next panel at this point, and after that panel, we'll all talk.